Hello, and welcome to our explanatory video, Data Protection, Privacy and Identity in AI-Driven Media, as part of the Erasmus Plus co-funded project, Deep Tech for Creative Trust. In this video, you will learn what GDPR actually means in practice for educators using AI tools, where the real data risks lie, and how to build consent-aware habits that protect your students, your institution, and yourself. Let us be concrete about what GDPR means for educators who work with AI, because the legal reality is more immediate than many people realize. Under European data protection law, biometric data, voice recordings, facial images, fingerprints, and behavioral patterns, is classified as special category data. Using it requires explicit, informed, and specific consent. Not assumed consent, not buried terms of service. Explicit consent, documented. What does this mean day to day? If you record a student's voice in class and then upload that recording to an AI tool for transcription or analysis, without their clear consent, you are in violation of GDPR. If you photograph students and use those images in an AI tool, same problem. These are not edge cases. They are common practices that many educators have not yet examined. Concrete tip: before introducing any AI tool into your teaching, ask 3 questions. First, what data does this tool collect? Second, where is it stored and who can access it? Third, is there a GDPR-compliant data processing agreement with the provider? If you cannot answer all 3, the tool is not ready for your classroom. Identity rights go further than legal compliance. Every person has the right to control how their voice and likeness appear in AI-generated content. Just because something is technically permitted does not make it ethically sound. As educators, we model professional standards, and that includes how we handle people's data. One misconception to address directly, it's online so it's public, is not a valid legal position in the EU. Public availability does not equal consent for AI processing. Full stop. Here is a classroom activity that makes these principles concrete and genuinely engaging. In a voice clone case study workshop, present students with a realistic scenario. A voice clone of a well-known educator appears in a synthetic video circulating on social media. The person never gave consent. What happens next? Divide the class into 3 simultaneous analysis groups. Group 1 works the legal angle. Which GDPR articles apply? What rights have been violated? What are the legal remedies? Group 2 takes the ethical perspective. Beyond what is legal, what is right? What harm has been done and to whom? Group 3 looks at the institutional level. What policies should have been in place? What should the institution's response be right now? After each group presents, move to the applied part. Together, students draft a GDPR-compliant consent protocol for a fictional media production module. They specify what data may be collected, by whom, for what purpose, how long it is retained, and under what conditions it is deleted. Concrete tip for educators: use this protocol drafting exercise to audit your own practice alongside students. What data do you currently collect? Is each collection lawful, necessary, and transparent? What would you change this week? Modeling honest self-reflection here is powerful. Key takeaway: data protection in AI-driven education is not a compliance checkbox. It is a form of care, evidence that you take your students' rights seriously as professionals and as people. Practical action for this week: identify one AI tool you currently use in teaching. Look up its data policy. Check whether it has a GDPR data processing agreement. If you cannot find the information easily, that is your first signal something needs to change. When we protect student data rigorously, we do not limit creative possibility. We build the trust that makes technology-rich education sustainable in the long run. Thank you for your attention.